Hello, I'm Kara Wenzel. I'm a program attorney here at Quimbee. And today I'm going to be talking with Scott Arnaud. Hi, Scott.
Hi there, Kara. It's a pleasure.
Thank you so much for joining us. Our topic today is legal ethics in cybersecurity. But before we get started, I just want to give you all a little brief background on Scott. Scott is an attorney and a founder of the Security Advocate, which is a company that assists organizations in addressing information security and data privacy issues. This includes privacy and security awareness training, security consulting, compliance with cybersecurity and privacy laws, and related legal concerns. Prior to that, Scott spent over a decade as a litigation attorney in the New York City area. He was lead counsel for Private Client Services Group at Smith Barney. So he uses this unique background in legal, security, and business to make complex information security concepts easy to understand and even to entertaining on occasion, which hopefully you will see. Scott has published security-related articles in national publications ranging from New York Law Journal to SC Magazine. He's also created and delivered numerous presentations on information security and data privacy-related issues for executives, managers, professionals at a range of organizations, including the New York State Bar Association and NIST, the National Institute of Standards and Technology. Scott is certified information systems security professional, and that's a bit of a mouthful. He is admitted to practice law in New York, the state U.S. district courts for the Eastern and Southern districts of New York, and the U.S. Court of Appeals for the Second Circuit. Scott is the author of Introduction to Information Security Live Lessons video training series for Pearson Publishing. So thank you again, Scott, for joining us.
We will
be having you and your time and your expertise. I was looking over the handout that you prepared, and frankly, I think I was a little nervous to read it because there's a lot to know here, right? First, I want to tell us a little bit about how the ABA has addressed kind of the evolution of the internet and what the security concerns, have brought to light in the past couple decades, I suppose.
Well, sure. I mean, they'd had some stuff earlier relating to general sort of confidentiality of information, but they didn't really sort of tweak it in for security until about 10 years ago. Starting in 2009, the ABA created what's called their Commission on Ethics 2020. Among other things, it reviewed the model rules, basically looking for the effect of technology upon the legal profession. And as a result of that, what they came up with were 3 amendments to rules which were implemented in August of 2012. Actually, they were changes to the comments to the rules, but sort of clarifying them specifically to deal with security.
Well, it seems like often the comments have the most interesting insight rather than the text of the rule, right?
Exactly.
Yeah.
The rules tend to be a little, I don't want to say vague, but vague. And the comments say, okay, this is how you apply this, that type of thing.
Well, why don't we start from the top? Tell us which model rules were changed, and then we'll kind of go from there.
Sounds good. Well, the 3 that had actual changes made were Rule 1.1, which is basic attorney competence, 1.6, which is confidentiality of information, and 5.3, which is responsibilities regarding non-lawyer assistance.
Okay. So competence, model rule 1.1. What changed there?
Well, in that case, again, it was a comment. This was a language added to comment 8. And I'll read you the comment and mention the new part. It's a whopping 9 words. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, new part, including the benefits and risks associated with relevant technology, end of new part, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Literally, that's the full change, just the 9 words. But that seemed to make a bit of a sea change in terms of saying, oh, this applies to technology, and you've got to keep up with what the technology means in terms of storing and securing data. And there was a report that accompanied the amendments, which came out also in 2012, which, if you'll forgive me, I'll read from that one too, just to let you know what they were thinking. Quote, The proposed amendment, which appears in a comment, does not impose any new obligations on lawyers. Rather, the amendment is intended to serve as a reminder to lawyers that they should remain aware of technology, including the benefits and risks associated with it, as part of a lawyer's general ethical duty to remain competent. Plain English, it's not a new duty they're putting in place. What they're doing is letting you know it was already there, and oh, by the way, don't forget about this.